Hello and welcome to the channel. If you like the content, give us a thumbs up and share the video. Please subscribe to the channel and press the bell icon for future video notifications. The Babri Masjid Demolition, a representation of timeline and judicial conclusion. The land on which Babri Masjid was built gave rise to a dispute between two religious communities, Hindus and Muslims, both of whom claim ownership over a piece of land measuring 1500 square yards in the town of Ayodhya. The disputed property is of immense significance to Hindus and Muslims. The Hindu community claims it is the birthplace of Lord Ram, an incarnation of Lord Vishnu. The Muslim community claims it as the site of the historic Babri Masjid built by the first Mughal emperor Babur. Masjid is a Muslim place of worship. One such masjid was situated in the east of India at a place called Ayodhya in the state of Uttar Pradesh, India, and was known as Babri Masjid. The mosque was located on a hill known as Ram Kot or Rama's Fort. According to Hindus, Baki destroyed a pre-existing temple of Rama at the site. The city of Ayodhya is identified as being the birthplace of Lord Rama. Owing to the belief as the birthplace of Rama, Ayodhya or Awadh has been regarded as one of the 7 most important pilgrimage sites or Sattapuri of Hindus. It is believed that the birth spot of Rama was marked by a temple which is said to have been demolished by the orders of the Mughal Emperor Babur and a disputed mosque erected in its place. On 6th December 1992, car sevaks started accumulating at Ayodhya near the Ram Janmabhoomi. There was a pre-announced court-permitted Karya Seva organized. There was tight security arrangements at the place of Seva to deal with any contingent situations. Around 12 p.m., thousands of car sevaks started trying to enter through the police barriers and ultimately they succeeded in entering the disputed Babri Masjid site. The gathering started demolishing the disputed structure with ropes, spades, hammers, etc. The police was not able to control the crowd despite of many measures like tear gas, and by 5 p.m. the entire disputed structure of Babri Masjid was demolished. Near the demolishing site there was a stage, and around 10 a.m. on the day of incident, Ashok Singhal, Giriraj Kishore, Lal Krishna Advani, Murli Manohar Joshi, Vishnu Dalmia and Uma Bharti were giving aggressive speeches, and the car sevaks were breaking the structure while the speeches were going on. There are 2 types of cases which have been recently closed by the courts of India, putting an end to all kinds of speculation about Babri Masjid. Case 1. In the Supreme Court of India, judgment given on 9th of November 2019 about the land ownership dispute. Case number 2. Special Court Lucknow, Ayodhya Case. Judgment given on 30th of September 2020. This was the criminal case for Babri Masjid demolition. Since the year 1856, there are recorded conflicts between Hindus and Muslims at the Babri Mosque. One such incident in 1856 led to the setting up of a railing made up of grill and brick wall outside the mosque. Nihang Singh, in the year 1858, erected a religious symbol inside the mosque. Since 1860, people have been approaching the courts to establish some kind of ownership over the Babri site. In 1882, Mahant Raghubar Das filed a suit for organizing Ram Navami fair near the site. Later, Raghubar Das filed another suit to build a temple at the disputed site, which was not granted to maintain communal peace. In the year 1934, one more communal riot happened and the deities of Sri Ram Lalaji were installed at the site. In 1949, the site was declared disputed and the last Muslim prayer was offered during the same year. By 1950, the site was under the supervision of municipal board and the status quo was maintained until the 1992 demolishing incident. In the year 1992 and after the Babri Masjid was demolished, cases were filed against 49 people and the investigation was handed over to CBI. Meanwhile, in the civil land dispute case, the High Court ordered an ASI-led survey of the disputed site. In the year 2010, a bench of 3 justices divided the disputed land equally among the 3 parties. The 2010 order was later taken up by Supreme Court and a 5-judge bench gave the final verdict in the year 2019. The Babri Masjid Demolition Case was named as a criminal case in the year 2017 and the case ran non-stop in the Special Court for Ayodhya Matters, Lucknow. A final judgment was given in the year 2020. In its final judgment, the 5-judge bench concluded, 3-way bifurcation by the High Court is legally unsustainable. The bench directed that land measuring 5 acres be allotted to the Sunni Central Waqf Board either by the central government out of the acquired land or by the government of Uttar Pradesh within the city of Ayodhya. The central government shall, within a period of 3 months from the date of this judgment, formulate a scheme. The scheme shall envisage the setting up of a trust with a board of trustees or any other appropriate body for construction of a temple. Possession of the inner and outer courtyards shall be handed over to the board of trustees of the trust or to the body so constitute. The final Supreme Court judgment put an end to the land ownership issue which started way back in the year 1856. The Special Court of Lucknow Ayodhya chapter found all persons charged as not guilty and freed them of all the charges of Babri Masjid demolition case. The court listed below main reasons to dismiss the charges against the accused. There are differences in witness statements. None of the witnesses have identified the named accused as the person responsible for demolition of the mosque. It is hard to believe that among thousands of people, any one man or few men can order such an demolition act. The investigating agency CBI only presented circumstantial evidence to prove the charges, which is questionable. Based on facts, it is concluded that the Babri Masjid demolition was not predetermined and there is no proof of a group planning or criminal conspiracy. There was a different group of people who carried out the demolition and they are not named in the FIR. Media witnesses have admitted that none of the photographs submitted as proofs were collaborated with actual negatives. None of the negatives were presented as evidence. The genuinity of the submitted photographs was not established by an independent agency. None of the electronic evidences like video cassettes were original and they were all edited before submission to court's consideration. The original copy of news submitted by the field correspondent was not available in unedited or original form. For that reason, published news and articles cannot be considered as evidence.